Thank you all so much for joining us for this Wednesday webinar on employment and epilepsy. Just a couple housekeeping items before we get started. This webinar should be about an hour long. I'm going to hopefully leave Cindy with a little extra time so she can answer as many questions as folks will have. If you have anything else open on your computer, any web browsers, any sort of music app, if you could close that down, just because it'll make it easier for the webinar to play on your computer. We are recording this, so if you have anybody who would like this information in the future, or if you wanted to go back for any specific part, you can please reach out to us and we can connect you with that. It'll be on our website. As you can see, we do have the closed captions going on below. You can click on the closed caption button to close it out if you don't want it, but it's there for those who would like it. And because of that, we'll also be able to provide a transcript of tonight's webinar. Down there, you can also see there's this Q&A button. The chat is disabled for this webinar, but if you have any questions, you could submit them through that Q&A button on the bottom. And then I'll share those with Cindy when we get to questions towards the end. If there are any technical issues you're having, you can submit a question there too, and Mary will be happy to help you out with whatever difficulty you might be having with Zoom. And so now we do have a poll question for everyone just to kind of get a gauge of where we all are in coming to this webinar. So I'll just give everyone a minute or so just to let some of the answers come through. Wonderful. Give another second for anyone else who wants to, who hasn't answered yet. Okay. My name is Martin Hernandez. I'm the Regional Outreach Manager working out of Rochester. I cover parts of southern Minnesota. The objectives for tonight's presentation, we hope to increase the knowledge of how epilepsy and seizures can impact employment. We want to gain a deeper understanding of the ADA, as well as discussing how Title I of the Americans with Disabilities Act of 1990 prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against disqualified individuals with disabilities on job application procedures, hiring, firing, advancement, compensation, job training, and other terms, conditions, and privileges of employment. Before I turn it over to Cindy for her information, I'm just going to provide a little bit of information that we have here at the Epilepsy Foundation. So we know currently 1 in 26 people will develop epilepsy at some point in their lifetime. However, the number of folks who will have a seizure at some point in their life is a lot higher at 1 in 10. Approximately 54,000 people in Minnesota currently have epilepsy, and we do know that we have approximately 200,000 new cases of epilepsy and seizure disorders being diagnosed each year. It's the 4th most common neurological condition after migraine, stroke, and Alzheimer's disease. It's the leading brain condition in children. About 1/3 of the people who live with epilepsy are actually doing so with uncontrolled seizures. We know just how important it can be to have control of one's seizures. Adults with epilepsy are also more likely to have 4 or more co-occurring chronic conditions. Those would be things such as mood disorders, ADHD, migraines, and sleep disturbances. People with low economic status are 2 to 4 times more likely to have seizures. African Americans and Hispanics are nearly 40% of those who are diagnosed with epilepsy. About 1/3 of the children who live with epilepsy do so in food insecure homes, and about half of adults who have active epilepsy will have a family income that averages less than $25,000 a year. So obviously here at the Epilepsy Foundation, our main focus is working with the epilepsy community, specifically here in Minnesota. So when we talk about epilepsy, what exactly is epilepsy? It's a neurological condition characterized by unprovoked and recurrent seizures. So the keywords there being neurological, so the person's brain is being involved, and then unprovoked and recurrent. And so these are seizures occurring for no particular reason. There's no medical condition that's causing them to have these seizures. And then recurrent, so someone is actually having multiple seizures. When we mention that 1 in 10 can have a seizure, many times that might just be a singular seizure, as opposed to that 1 in 26 who live with epilepsy, where they're having recurrent seizures, so multiple seizures instead of just the one. In the past, it may have also been referred to as seizure disorder or seizure condition, but we really recommend using the term epilepsy as it's the most correct term for this condition. Then when someone is having a seizure, what is actually happening in their brain is this sudden and uncontrolled amount of electrical activity occurring briefly in their brain. Seizures can occur with other conditions besides epilepsy as well. We know that someone can have a seizure when they're going through drug or alcohol withdrawals. There are febrile seizures that can be brought on by a high fever, as well as diabetic seizures that can occur when someone is having an imbalance in their blood sugar and insulin levels. And depending on what part of a person's brain is actually having that seizure activity, that will determine what the seizure is going to display like throughout their body. With that, I'm going to turn it over to Cindy so she can present on the ADA and employing people with disabilities. Cindy.
Okay, Martin, thank you. And thanks everybody for inviting me here from my living room to yours. I am most honored to present to you tonight about the ADA and employment, which is the Title I of the ADA. Perhaps next slide, please. Okay, so that was me many years ago. I am the director of ADA Minnesota. I have been there, I believe, for about 19 years, but have spent pretty much my whole career in disability services one way or another. ADA is funded two ways. One is through the Great Lakes ADA Center. If you've ever contacted them, they represent about 6 states, and they're part of the ADA National Network. They get their funding from NIDLR, and then they pass it on through to us so we can do our activities. The other portion of my program costs are paid for by the Metropolitan Center for Independent Living, because ADA Minnesota is a program within the Metropolitan Center for Independent Living. So that's my commercial there. Next slide, please. Okay, so I always joke that I am in the Guinness World Book of Records as the world's fastest talker. And I think I might be, but you know, I have so much great information to get to you tonight, and I'm super excited and passionate about the ADA. We just celebrated the 35th anniversary of the ADA this past July 6th. We had a huge virtual presentation. We had about 400 people on that. So the silver lining of the pandemic is that when you host a virtual event, anybody and everybody can attend. This is what I want to get through tonight, and this is why I talk fast. But if there is a problem, Martin will tell me to slow down. And if you have any questions, of course, you can put that in the Q&A, I believe. So we'll get to those at the end. What I'm going to cover tonight is I'm going to give you a briefest of brief overview of the 5 titles of the ADA. Then we're going to sink in and discuss Title I, which is the employment title. And I would say probably 90% of the calls that I get for individuals that have epilepsy pertain to employment. So perfect fit. I'll give you kind of the disability definition of who is a person with a disability under the ADA. We'll talk about essential functions and applications and the interview process and all those good things that come along with getting a job. We'll talk about direct, threat, and undue hardship, which are kind of the safety net for the employer. Disclosure and reasonable accommodation, if you've ever had to disclose that you have epilepsy and or ask for a reasonable accommodation, you know what that's about. It's a little bit complicated there. And resources, both local and national resources I'll share with you. Next slide, please. Okay, so here it is. There will not be a test at the end or a poll or a quiz, but if you could leave tonight knowing that there are 5 titles of the ADA. The first title is the employment title, and the way the federal law, it's a federal law, of course. I like to say it's the civil rights legislation for people with disabilities. And the federal law says that it covers all employers with at least 15 employees. So really, in 1990, it was written that way to protect the small businesses. But in Minnesota, we have something called the Minnesota Human Rights Act. And the language there states that that employer covers all employers with at least 1 employee. So that would be all employers in Minnesota are covered under the ADA. Title II is our state and local government, and that covers all programs, services, and public activities that get state and local dollars to support those programs. So like your public library would be a good example, or the courthouse, or any of the state agencies. Let's say the Department of Revenue is having a workshop or a conference on how to do your taxes. Let's say when we're allowed to have public events again, they would have to make sure that it's accessible to people, maybe provide alternative format or have an interpreter, or hold it at a site that's accessible to individuals that use mobility devices. So state and local governments are covered under Title II. All the programs, activities that they provide have to be accessible. Title III are public accommodations. These are the places that we are starting to go back to: our restaurants, our stores, our hotels, motels, places of business. Any place the public is allowed to attend and welcome to attend falls under Title III. And those entities also have to be accessible to people with disabilities. Title IV is our telecommunications, that every state says that they have to provide effective communication. So what they provided at the signing of the ADA was the 911 relay service. I don't know if you've ever used that service, but for individuals who are deaf, hard of hearing, or have speech issues, and people want to communicate with them, but they don't have a TTY or a TTD, you can just pick up your phone and call 911, and you get your own interpreter, and then they will contact the individual with the disability, whether it be hearing or speech, and they will communicate with that individual, generally through TTY, but now some through video relay, and then they'll get back to you and speak voice. So it's very nifty. There's no excuse if somebody has a disability and the employer says, well, I couldn't reach you. All they need to do is pick up the phone and call 911, and anybody can use it. And Title V, miscellaneous title, that includes things like retaliation, insurance, attorney fees, things like that. A lot of those issues over the past 31 years have been resolved, so not a lot of presentations on Title V. So next slide, please. So again, remember 5 titles of the ADA. We are talking about Title I. So Title I, the general rule is that no employer should discriminate against any qualified individual, and we'll talk about who is a qualified individual with a disability in regard to any aspect of employment, from soup to nuts, as they say, right? It's the recruitment. If they are recruiting for that job on their website, they have to make sure that their website is accessible to screen readers for individuals that are blind or low vision, right? They also, let's say you have the job, they have to make sure that all the benefits, the goods, the services, the employer-sponsored events are also accessible to people with disabilities. So let's say they're having it at a restaurant, and some of the staff or one of the staff uses a wheelchair. Let's say they'd have to make sure that that site, that facility, venue, restaurant is accessible to people that use wheelchairs. Or let's say the individual, for once a month for staff meeting, they have an interpreter, an ASL interpreter. They'd have to make sure that that interpreter was present at the holiday gathering. Okay, next slide, please. Okay, so I kind of talked about like who is somebody with a disability under the ADA. It's different than if you get SSDI. It's different if you've got disability parking. It's different from workers' comp. It's most similar to, I'm such an ADA nerd, but it's very similar to the language if you know the Rehab Act of 1973, where Section 504 is from. So if you or your child or a family member has ever had a 504 plan in high school, that's where it comes from. So that was from 1973, again, ADA 1990. So they took some of that language. So who is a person with a disability under the ADA? You would have to fit to have the protection, right? Under the ADA, you'd have to fit into one of those 4 bullet points, right? Not all of them. I made that mistake once. It was not clear and I confused the heck out of my audience. But so first and foremost, the individual maybe has a physical or mental impairment that substantially limits one or more major life activity, right? So what are those things, those impairments? They are the original, walking, talking, seeing, hearing, those types of daily life activities. What I find interesting is that eating was not necessarily included in major life activities in the beginning. It changed because, and I'll tell you the story of it. There was a pharmacist who had diabetes, and it was a small pharmacy, and was told by the owner of the pharmacy that the individual could not take a lunch break until there were no customers. So it was getting very late in the day, 2, 3 o'clock, till he finally got his lunch, and his blood sugars were not doing well, and he was not making good decisions. So from that and other cases, it was determined that yes, eating is a major life activity, and it's very helpful for individuals who maybe their medication gives them dry mouth, or they have low blood sugar and they need to have like a piece of candy or an orange, be able to eat at their desk, whatever that may be. So that's the first prong. That's where the majority of the people would fit into, people that have a mental or, a physical or mental impairment that substantially limits one or more major life activities. Then there are those that are covered that have a record of such an impairment. Let's say they no longer are impaired in any way or substantially limited in any major life activities, but they have a record of it. So in the past, let's say somebody who has cancer, but then has been in remission for 10 years, and they're applying for a job. Somebody knows somebody that finds this out, and it tells HR, and the person doesn't get the job because maybe they're concerned that they're a health risk, that their insurance benefit rates will go up, whatever it may be, and they don't get the job because they have a record of having an impairment. They are covered under the ADA from discrimination, right? Then there's the individual who is regarded as having such an impairment. So they are not substantially limited in any major life activities. They have no record of it, but somebody thinks that they do. And in doing so, they discriminate against them, they're covered, right? So that's an interesting thing. Then the final one is association with a person with a disability. So let's say they are not substantially limited, no major life activities, no record, they're not regarded, but let's say they have a child at home that has a disability, right? And they're applying for a job, small town, whatever it may be, and the employer knows this, and they're not given the job because the employer thinks maybe they're not going to be dependable, a dependable employee because they have a child with a disability. They can't do that. Where the coverage does not cover the employee or the prospective employee is that, let's say, okay, we go to the employer, we say, no, you can't discriminate just based on the fact that this person is a family member with a disability, right? Then the person gets the job. They are not covered for accommodations. So they couldn't then say, okay, well, now I need to take Tuesday and Thursday afternoons off to take my child to physical therapy. That doesn't work because the accommodation is for the individual, not for the family member. Okay, so clear as mud, right? Okay, hope I'm going fast enough for everybody. Next slide, please. All righty, so very exciting news. In 2008, 2009, there was a thing called the ADA, Amendments Act, right? And what had happened was there was some really horrific Supreme Court decisions. So we called it the trifecta because it basically made it so that it narrowed the scope so tight of who was considered a person with a disability that nobody was considered a person with a disability. They were using mitigating measure and all the craziness. So what happened was the business community, the disability community, they all got together in the legislature and said, this is not right. And so they created the ADA Amendments Act, where they widened out the scope of who was covered. And in doing so, really took a good hard look at major life activities, right? So the Amendments Act has 2 non-exhaustive lists, meaning doesn't cover it all. But the first list was the original one, where it was walking, talking, eating, speaking, all of those things, right? And then the second list was those that were kind of in the gray area that the EEOC, did they recognize? Did they not recognize? Nobody was sure. So that's reading, bending, communicating, concentrating, things like that, right? Then the thing that I got so excited about was the major bodily functions, okay? So these are the things that occur within your body, right? So much like epilepsy, I would imagine. So these are things that occur within your body, things like your immune system, normal cell growth. If I were to ask you, what is abnormal cell growth? What would you tell me? If we were in person and I could see you, you would probably say, oh, abnormal cell growth is cancer. So now people that have cancer are covered. Digestive, bowel and bladder, all of these things that occur in your body are now considered major life activities, right? So I get calls all day long and emails and this comes out and I'm like, oh my gosh, I'm waiting by my phone for somebody to call me with a major bodily function issue, right? Need somebody to call me so I can use my new tool, right? Nobody calls. So several months later, I get a call from an individual and he said, I think I'm being discriminated against because he tells me that he does not have a colon and that he has to do things differently in the restroom. And his employer and other employees are standing outside the restroom, timing him for how long it is taking him in the restroom. I know, I wish you could see the look on Martin's face right now. So I'm telling you, it was not good all around. They were timing him and then they were telling him that he would have to come in early, stay late, couldn't take a lunch break, all of these things to make up that time. So I'm talking to him, none of it is sounding good to me, but then I'm thinking, major bodily function. This is occurring in his body, right? What are we going to do about it? So I said to him, well, do you work on a production line? Like, do they have to stop production because you're in the restroom? He said, no, as it turns out, he is a supervisor, a manager. He runs his own schedule and he is able to get the essential functions of his job done, right? He just takes a little bit longer in the restroom, but gets the job done just fine. So I'm thinking, oh dear. So we go to the employer and we say, this is discriminatory. You can't be standing outside the restroom. And even though this gentleman did not need accommodations because he was able to get the essential functions done, we determined, it's best to get it in writing. And we asked for the accommodation of a flexible work schedule. So he can determine his own work day, right? As long as he's getting that job done. And part of the accommodation was that they could no longer be timing him outside of the restroom, right? I think I hear it all. And then the next day I get another call. So next slide, please. I'm going to be peppering this presentation. I think you're not going to remember all my facts and statistics, but I think that the thing that will stick are the actual stories of the calls that I've gotten. So that's what I'm hoping to pepper this presentation with today. So hang in there with me. So essential functions of the job are the same for people with disabilities and without disabilities, right? The ADA is not an entitlement program. It never was meant to be. If you have a disability, you don't get to leapfrog over other people that are less qualified. You still have to be able to do the essential functions of the job with or without an accommodation, right? Again, it's an anti-discrimination law, but it's not an entitlement program. So that being said, every individual still has to be able to satisfy the skills, have the education and the training for the position, right? Should employers, put that in the job description, the essential functions? Yes, they should, because how else would anybody know if you're able to do the job if you don't see the job description, right? Okay, next slide, please. Okay, so this is in the application process. These are 3 things that just don't sit well with me. So I'll share them with you. And if you ever come across these things, you most certainly are welcome to call me and I can guide you on what to do about it. Excessive job requirements and criteria, right? So saying that everybody has to be able to lift 50 pounds. That was a real popular essential job function in the 90s, so that everybody had to lift 50 pounds. And what that did was that it basically screened out a lot of people with physical disabilities, right? So they can't have excessive job requirements and criteria. Where this is important for you guys is that a lot of employers will put down that you have to be able to drive to do the job, or you have to have a valid Minnesota driver's license, right? But you don't. So if, because a lot of people either are not able to drive or they've had a seizure and maybe 3 months out that, they can't drive for 3 months or whatever it might be. So they can't ask you if the job doesn't require you to drive, then they can't ask for a valid Minnesota driver's license. They can ask for a valid Minnesota identification card, which you also can get at the DMV, right? But again, if the job doesn't require you to drive, they can't ask for that valid Minnesota driver's license, right? And they can't put on every job description that you have to be able to drive, unless indeed the essential job function is driving. And then of course, but not every job requires you to drive, right? It's not the essential function. Might be a non-essential function. You know, once a week you drive to the other location to switch out merchandise, but you're not, you know, driving a bus, right? Then there's the online application, making sure, I think I mentioned that, making sure that the application itself is accessible to screen readers, and they're not, can everybody see that, or is that just me, Martin? That little box? Okay, it's gone. Maybe it was just me. That the application itself is accessible to screen readers, and also that they're not asking things that they're not allowed to ask. They cannot ask, you know, are you a person with a disability? Or are there, you know, any disabilities, or list them? They can't ask that at the application process, right? What some employers do, and I found this not as recent as in the past, but they have the job application and they list the essential job functions. So yay. And then they have little circles next to it, and you're supposed to fill in the essential job functions that you will require an accommodation for. So think that one through. Why, you know, the ADA is the only language where you need an accommodation. So basically they're asking you to disclose on the application that you need an accommodation, which indeed forces you to disclose that you are a person with a disability. So next slide, please. I hope you guys are still with me. Okay, so next slide. Yes, so we're going to kind of get into the disability related questions and medical exam piece. It's a little tricky. This is a whole presentation in itself, but I'll give you the shortcut. So pre-offer, before you're even offered a job, they cannot ask you any questions or examinations of the applicant at all, right? So meaning like on that job description or on that application online, like if they were to ask, you know, they're not offering you the job, but they're asking you if you're a person with a disability, they can't do that if they've not offered you the job, right? So there's a small little window post-offer where they can kind of ask a few questions, as long as they're asking it of all applicants and they're not asking the questions to screen you out as a person with a disability, but just to see if you're able to meet the criteria of the job, right? So post-offer, they may say, we would like to offer you the job. You know, they're saying that you have the skills and you to do the job, you're qualified to do the job, but they want you to see the company doctor. They need you to show that you can, you know, do X, Y, and Z, drive the forklift or whatever it might be. So then they can do some examinations, right? They can't use that information again to pull the job unless it would prove that you're not qualified to do the job. Then the window closes, you get the job. Then if they ask you any of these questions during employment, it has to be job related. Right? Again, it can't be to screen people out because they don't want to pay for everybody's insurance. It has to be consistent with business necessity. Also, they can always ask to process an accommodation request if the disability is not obvious. If it's we call it now a non-apparent disability, which used to be called a hidden or invisible disability. But if the disability is obvious, then they should need medical documentation. But if it's not apparent, then they can ask for medical documentation. Next slide. Okay, so the job interview, things that the employer cannot ask you during your interview. They can't ask you about an impairment. They can't say, you know, for emergency preparedness reasons, we need a list of all the medications you're on. They can't ask for that. They can voluntarily ask, I guess, but they can't require you to give a list of medications. They can't ask if you have a history of workers' compensation because you may have obtained a disability from that. And they can't ask about your mental health. They can't say, and I've heard this, like, this job is really very stressful. Do you have any anxiety disorders? Do you have any heart conditions? You know, again, this is a stressful job. What job is not stressful, right? I'd like to know. So next slide, please. Okay, so here are some examples. Do you have a heart condition? Do you have a disability which would interfere with your ability to perform the job? They cannot ask how many days you were sick last year, but they can ask, tell us about your attendance record, right? Because you might just not be a great employee and, take off every Friday or Monday, but they can't ask about your sick time. Again, because that may be because of your disability. They can't ask if you filed for workers' comp or been injured on the job. Next slide, please. So what can they ask? They want to make sure they get the right employee, and you want to make sure that this is the right job for you, right? Well, the main thing they can ask you is, can you perform the essential functions of the job with or without an accommodation? They're not asking you to say if you need an accommodation or if you're a person with a disability, just, are you able to do the job with or without an accommodation? You're not disclosing anything. You're just, you look at the job description. Now, there might be something that you may need an accommodation for. You might need, a larger screen on your computer, whatever it might be. And that's a reasonable accommodation. So you can say, yes, I can do the job with or without accommodations, right? They can ask about current illegal use of drugs, because illegal drugs and also illegal use of drugs, which are two different things, are not allowed under the ADA. It's a federal law, and illegal drugs are illegal under a federal law. And also they can ask you about any history of a workplace violence, even if the violence is a symptom of your disability. It doesn't matter. Workplace violence it's never tolerated. So next slide, please. I see that Mary has her hand up. Is there a question there, Mary, or? Nope. Okay. Just checking. I don't know why I see the hand up there, but.
No, I think it's okay.
Okay. All right. Moving on. Okay. So the job interview, right? Permissible questions. So what can they ask you at the job interview to make sure that you're the right applicant, right? They can ask you why you left your previous job, right? They can ask whether the applicant will need a reasonable accommodation for the application process only, right? And if they're going to ask during the application process, if you need an accommodation for the application process, not for the job, because let's say you have a non-apparent disability, it's not obvious, right? They have to, or they should, let me put it that way, they should ask that of all applicants, not just the people that they think have a disability. Because here's a little secret, the largest group of people with disabilities, the largest group are those that have non-apparent disabilities that you can't tell, right? So the EEOC does say, and that's the Equal Employment Opportunity Commission, they do say that if somebody with an obvious disability requires a reasonable accommodation to perform the job. So they can ask, let's say somebody is blind or low vision and they come in to apply for a job that's all on the computer. And the person that's interviewing them has never worked with anybody that is blind or low vision. They may say, are you going to need an accommodation? How will you do this job? It's all on the computer, it's all keyboard. And then hopefully the person with the disability, maybe who is blind, will bring in their computer that has screen reader software in it and do a demonstration of how they would do that job in the best world possible. Next slide, please. So during employment, let's say you have the job, right? What the EEOC says that if the employer has a reasonable belief based on objective evidence, right? That the person is either unable to perform the essential functions of the job, right? Or they will pose a direct threat because of a medical condition, then they can ask them about the disability, and also maybe get documentation from their medical provider that they're able to perform the essential functions of the job. So the one about the pose a direct threat, that's always a good one, because it's really a high bar, to prove that the person is posing a direct threat. Has it happened? Sure. But that being said, I did have, can I have a next slide, please? I'm talking about this, Martin, thank you. So I did have a situation where an employer called me and he said, oh, I think I have a direct threat, a safety issue with one of my employees, and I think I'm going to have to terminate them. So I'm like, okay, I'm like Switzerland. I'm very objective. I represent a federal law. I can't make changes. I can't add anything to it. I said, what is the situation? And he said, well, I have an employee, and I think he said he had Parkinson's or some type of impairment where his hands were shaky and unsteady. And he said, and I have this employee, right? And we work in long cubicles. And at one end of the cubicles is the coffee maker, and at the other end of the cubicles is his office. And we are very concerned that when he gets his coffee, that walking back to his cube, he's either going to spill this hot coffee on himself or his coworkers, right? So I take out my laundry list of my safety concerns for direct threat. And I talk to him, I'm like, what is the nature and the severity of the risk? What is the likelihood that it's going to happen? Has it happened before? What is the imminence of the harm? Have other employees expressed concern about this, right? And the employer could not answer yes to any of these questions. So we determined, no, it's definitely not a direct threat, right? Hang up. And then I'm like, ooh, I missed my last bullet point, whether the risk could have been eliminated or reduced, right? Could they move the coffee pot to his end? Could they, give him his own coffee pot? Could there be lids? Could it be iced coffee? All of these things, of course, come to you after you've hung up the phone. But first and foremost, before you terminate that individual, the point being that they should try to see if the risk could be eliminated or reduced. Next slide, please. Okay. Is that okay, so is that the next slide, or can I see the previous slide for a second, please? I'm not used to doing my own. Okay, I guess it is. Okay, moving on. I forgot to have my little title slide that talks about disclosure. So we're going to talk a little bit about disclosing a disability to your employer. Why would an employee disclose their disability, whether it's apparent or non-apparent, right? And I'm thinking for the majority of people with epilepsy, it is a non-apparent disability, right? So the only reason that somebody really needs to disclose that they have a disability is to ask for a job accommodation, right? I've had people say, well, I really want to ask for an accommodation, but I don't want to tell them that I, have an impairment. Well, you have to at some point disclose this to get an accommodation. But two other reasons that you may choose to disclose that you have a disability is one is to receive if the employer has any benefits or privileges specific to people with disabilities. Some of them have a different parking lot or job fairs, or, October is a National Employment for People with Disabilities Month. Maybe there's some type of celebration. Some state agencies have committees that put events together. So that would be a reason. And the final reason is to explain an unusual circumstance or phenomenon. And I'll give you this example of a caller. I had a gentleman who called me and said, I think I'm going to be terminated. My employer keeps having me do UIs, the urinalysis, because they think that I am drunk on the job. My first question is, are you drinking on the job? Do you have alcoholism? Because I get a lot of those calls. He said, no. He says, I have diabetes and I can't get my meds regulated and my sugars are off. So it probably appears when I'm walking that I am impaired, right? That I am drunk. I said, well, have you disclosed to your employer? And he said, well, no, because I'm afraid that I will be terminated. And I said, well, you are protected under the ADA. They can't terminate you for disclosing you have a disability, but he was stuck on that because he said he doesn't need any accommodations. So he doesn't want to disclose. But I suggested that the accommodation may be taking some time off to get his medication in order, right? But I don't know if whatever happened, honestly, but I use that as an example for an unusual circumstance or phenomenon. So next slide, please. Okay, so what is the benefit that can come if you choose to disclose you have a disability to your employer, right? So first and foremost, you should be able to get the accommodation unless it's an undue hardship, right, for them. So you get the accommodation. Also, you can gain protection under the ADA, right? From discrimination, harassment from other coworkers, freedom from intimidation, all of those types of things. So in the best world possible, this is what happens. You get the accommodation and your life is great, right? So next slide, please. So why would somebody not disclose they have a disability, right? I'm sure that you, as a person with a disability, have thought this through in your head many times. This is nothing new to you, but one, perhaps the individual does not need an accommodation. You may have an impairment, a disability, a disease, a disorder, whatever it may be, but you don't need an accommodation, so you don't need to disclose. Or you're afraid that you're going to be stereotyped. It's not going to be kept confidential. You'll be retaliated. Your hours will be cut. It will be used against you. You'll get a demotion. You won't get a promotion, all of these things. Or simply you just want to remain private about your disability. So these things, I would love to say that this never happens, but it does happen. Unfortunately, not every employer is enlightened, after 31 years of the ADA on the protections under the ADA. So next slide, please. Okay, so what an employee may disclose. So the individual, you, the person with a disability, may give general information about your disability, why you're disclosing, maybe how your disability affects your essential job functions, what accommodations maybe have worked in the past, and what accommodations you think you'd like to request or require from your employer. Next slide, please. Next slide. Okay, who should you disclose your disability or to? Okay, go back to confidential. Was that the one previous? Did we miss that one? Okay, so who should the employee disclose to? This is really on a need to know basis. You do not need to tell the whole company, the whole management team about your disability and need for an accommodation. So oftentimes it's to the supervisor, right? The person who's in charge of hiring, promoting, firing. Sometimes it's the HR person. Sometimes if you work for a state agency, it's the ADA coordinator. Because here's another little secret. Every state agency is required to have an ADA coordinator, right? So again, it needs to be on a need to know basis, right? Next slide, please. Okay, here's my favorite slide, confidentiality of disclosure. So all of this information that you may disclose and any paperwork that accompanies it, let's say the company has a form that you fill out requesting an accommodation, and then you follow it up with medical documentation, it needs to be kept in the employee's, a separate lock file, separate from the employee's personnel file. So you think everything goes in your personnel file, but it does, except for anything related to the ADA, and your disability has to be in a separate lock file. Now during the pandemic, I'm advising employers to do it in a separate file on their computer, if possible, that only they can get into, because a lot of people have access to your personnel file. Right? We had an example of somebody who was up for a promotion, and the supervisor, manager in the other department that was going to promote them and take them on looked in the personnel file, which they certainly have every right to, saw the accommodations and didn't promote the individual. So that's why that's important. Again, it's a need to know situation. It doesn't have to be everybody. And also, I get a lot of phone calls from a lot of the union people, call me union stewards, and they say, we have a problem because we gave this individual an accommodation, and now other people are coming up to the supervisor and saying, do you have something special going on with this person? Why are you showing them favoritism? Why did they get the better parking spot? Why do they have the better shift? Whatever that may be. And the supervisor is really in a pinch because they can't say, oh, because they have a disability, because that would breach confidentiality. So basically we tell those people, that they can say, they're complying, with a federal law and it's confidential information. What they can't say is what the federal law is, because it's the Americans with Disabilities Act. And again, that would disclose the person's disability. So kind of a catch-22 there. Next slide, please. Thank you. So what the EEOC says about disclosure and reasonable accommodation, and this is super important, that's in red. That's why, it's very important that the person can disclose and ask for an accommodation at any time during the application process or during the period of employment, right? All the other stuff that's written there is important. This is the most important because employers really get hung up on this, as well as people with disabilities. And I'll give you an example. I had a woman that called me and said, that she has MS. And if you know anybody that has multiple sclerosis, oftentimes they have issues with like heat fatigue. If they're outside in the hot weather or in a hot building, it's not good. So she called and said she got hired in the winter. Everything was great. And then this was June, July. And she realized that the area that she worked was very warm. It was, in her part of the building, it was very, very hot. And she said, by noon, she had to go home. She was not well. So I said, okay, well, you may have to disclose to your employer that you have, you don't have to say you have MS, but you have to say what the impairment is. You never have to say what the actual disability is if you don't want to, just the impairment. Remember, we talked about if you're substantially limited in one or more major life activities. So the impairment for her was she suffered from heat fatigue because of her disability. We decided that pretty large company, be reasonable to ask for one of those wall unit air conditioners that you use in your college dorms or whatever, a wall unit air conditioner in her area of the building. Great. She goes to the employer. She calls me back the next day in tears, so upset. The employer said, oh, no, you didn't disclose during your interview or when we hired you that you have a disability. So we can't trust you. You lied to us. You withheld information, all these horrible things. And because of that, we're not giving you the accommodation. Right. And to top it off, now they don't trust her. Right. So, all of those things and more were wrong with that situation. We had an opportunity, I and her had an opportunity to discuss this with the employer and explain that that the ADA says, that the EOC says that, you can disclose that you have a disability at any time. Do not feel pressured to disclose that you have a disability. If you know that you're able to do the essential functions with or without an accommodation, you don't need to disclose at the interview, right? So what's so cool about this was that several months later, she called me back, and most people only call me back if things are not going well, but she called me back to tell me that not only was the air conditioner working well, but that productivity in her area, her department, had substantially improved because everybody was at a comfortable body temperature. So that was the good news there. It was a win-win for everybody. Next slide, please. Okay. What is a reasonable accommodation? Generally, it's any change in the workplace or the way things are normally done that provides equal opportunity for people with disabilities. So what I like to say, it is the thing, if you're a sports person, I am not, it is the thing that levels the playing field for everybody, right? So somebody with a disability has a reasonable accommodation, somebody without does not, levels the playing field, right? And generally the rule is, the employer provides the accommodation to the qualified individual. Remember, they're qualified to do the job, not an entitlement program, if they request it, and if it is not an undue hardship for the employer. Next slide. Dollars to donuts, it's going to be, what is undue hardship? So there's two types of undue hardship. One is if it is a financial hardship, difficulty or expense of a financial hardship for the employer. Let's say they're a smaller company and they really can't afford the expense of accommodation. If it's, maybe they could, before they say no, maybe they could find a different option for that accommodation. Also, there's the administrative hardship, sorry. And that is where it changes the nature of how they do the job. If it changes the whole way of how they do business to provide this accommodation, they don't have to. So let's say somebody's hours of operation are 8 to 4, and somebody works there and says, I have, let's say, narcolepsy, and my medication that I take at night, sometimes I have to sleep till 9, 10 o'clock. So can we change the hours of operation to start at 10 o'clock in the morning? Well, that would be an administrative hardship for that company to change their hours solely for that person. Okay, next slide, please. Okay, so the principles of an accommodation, one, it has to be interactive. The employer and employee have to have a conversation, a compromise, something has to occur. They can't just say no, without saying why, right? So there has to be interaction between the employer and employee. This is one of the first things that EEOC will ask and look for. Any type of documentation, whether there's email exchange or meetings or whatever it might be, that if somebody files a complaint against their employer, was there an interactive process, right? It also has to be effective. It can't be somebody who is deaf or hard of hearing asks for an interpreter during staff meeting and they say, no, just sit next to Cindy and she'll write notes back and forth to tell you what's going on. Well, first of all, that involves another employee. And second, ASL, is not English. It's a whole different language. So it would not be effective accommodation. So the obligation only to provide that accommodation is only to reduce the barriers as how it relates to that person's disability in the workplace, right? So let's say somebody says, well, our family likes to go to Disneyland in the winter months because that's better for my disability. Really, that has nothing really to do with their job and how their disability relates to their job. That makes sense? I can give you an example. There was an individual who rides Metro Mobility. If you know anything about Metro Mobility, it is the best system and the worst system all in one day. depending on when you want to take that ride, right? If it's during rush hour, forget it, right? But they're great. I love them. So this individual was having a hard time getting to work on time and said, because of my disability, I take extra mobility. Can we change my hours so I come in later and stay later so I'm not coming during rush hour? Sure, they made that accommodation, made changes that needed to change, so be it. Then the spring came and the person said, oh, I'm wondering if I could change my hours so I come in, earlier because my son has soccer practice and soccer games, at 4 o'clock in the afternoon. Well, no, they don't have to make that accommodation because it's really not work related, right? And then also the ADA says that the accommodation doesn't have to be the best accommodation as long as it's effective. It does let's say you're asking for software, it doesn't have to have all the bells and whistles as long as she gets the job done, right? So next slide, please. Okay, so what do we mean by interactive process? It's obvious, but it begins with a request generally from the person with the disability. There's no magic words such as, I require a ADA, as is my right under Title I of the ADA, I'm requesting an accommodation. None of that needs to happen. Basically, as long as the person's saying, I have a disability and I need some help to get my job done, that's good enough, right? It doesn't have to be in writing, but I always say to try to get it in writing, because oftentimes, your supervisor will change, or whoever approved that accommodation verbally is no longer there, right? Or doesn't remember it. You have no paper trail for that accommodation. So it is best to do the formal process and try to get something in writing, right? The request can come from other people, not just the employee, right? So it could come from me, maybe as an ADA coordinator, or let's say a voc rehab counselor, or oftentimes a parent of an adult child with a disability, right? And the ADA doesn't prevent the employer from going above and beyond what's required. Again, this is just the base level of what is required of that employer. But if they have a great employee and they're requesting something that they really don't have to provide, but want to provide it, absolutely, they certainly can do that to retain that employee. Next slide, please. Okay, requirements of an accommodation. I kind of went over this already, but the thing that I want to tell you is that you don't have to necessarily say what your diagnosis, disease, whatever it may be. You don't have to say you have epilepsy, but you just have to say what the resulting limitation is. Let's say you have MS. I was just use this example because we had already discussed about the heat fatigue, and they may say, you know what, I have a disability that impairs my gait and my ability to walk long distances in the heat. I'm requesting a closer parking spot and a bench to sit down on, right? So when I get in the building, something like that. So oftentimes, because if the disability is not apparent and you have to provide medical documentation, sometimes the medical provider will say what the disability is. You can ask them not to, but really all you have to do is say what the nature of the disability is and what the limitations are or the impairments. Okay, a lot of people don't know that. Next slide, please. Okay, so what happens? You've disclosed, you've asked for an accommodation. We have to process, is the request reasonable? So if the employer denies your accommodation, they need to show what evidence do you have to substantiate that it's unreasonable. What have you done? They can't just say no without saying why, right? So an example of that, another situation, had a woman who suffered from migraine headaches, and they were triggered by fluorescent lights that didn't have the shields over them. Most fluorescent lights now do, but they don't have the shields over them, right? So she gets a new job, and she's getting headaches because the fluorescent lights are triggering her migraines, right? And she says to the boss, the owner, whoever it is, I was wondering if I could request the shields, over the fluorescent lights. I had them in my previous job to prevent the migraines. And the person said, no, sorry, it costs too much. Right? Did they do their due diligence? I don't know, but I'll tell you that they didn't, because she was there on the weekends, had the lights very dim, was working almost in the dark. And the maintenance person said, what's going on here? And she explains the situation. I'm looking for these shields that go, screens that go over the fluorescent lights. She says, do you know how much they cost? She was thinking about buying them herself, right? And the maintenance person says, oh my gosh, don't worry about it. I have a whole bunch of them down in my workroom, right? Yikes. So she called me to tell me the great news that the issue got resolved because the maintenance person had them, but the bigger picture was, did the boss, the owner, the employer, did they do their due diligence, by just saying they cost too much? Did they even do the research with the maintenance person or anybody to see that they already had them? No, he did not. Also, you have to analyze it by case analysis. You can't generalize a whole group of people. And I will use this example. I use it in all mine. Had a situation where somebody who had epilepsy was told, no, they don't hire people that have epilepsy because they did have somebody that had epilepsy in the past and it didn't work out. First of all, everybody's situation is different. And you can't categorize a whole group of people based on your experience with one. Also, we have some employers that say, well, if we do it for you, then we have to do it for everybody. That's not a defense, because unless everybody has the same disability and is asking for the same accommodation, they're not entitled to the accommodation unless they're a person with a disability, right? So that goes right out the window. Well, if we let you do this, then we're going to have to let everybody do this. It's not a defense, right? So again, we always say to the employer, you better avoid saying no unless you can substantiate why, and that you reviewed your information before you deny the accommodation. Next slide, please. Hope you're all still with me here. Okay, if the request is reasonable, they can implement it, they can evaluate it and adjust it, right? They can monitor it periodically. What they can't do is keep coming back every 2 weeks to say, do you still need the accommodation? Do you still need the accommodation, right? But they, you can evaluate it maybe 6 months, maybe a year down the line, they revisit. The ADA Accommodations Act also now includes people with kind of exacerbating remitting situations or conditions, right? So that the person only uses the accommodation when they need it. That's kind of a cool thing that came with the Amendments Act. So what they can't do, and what did happen to an individual, was they can't harass the person. Had an individual, I think they were paraplegic, and they asked for something that would help them with mobility, right? And they kept coming back. Do you still need the accommodation? Do you still need the accommodation? Finally, it got so ridiculous that they finally said to the employer, I'm never going to walk again. And yes, I'm always going to need this accommodation. I put an end to it. Okay, next slide, please. Okay, so if reasonable accommodations may include, let's say it works out, they get the accommodation. Some may be, physical modification to the workplace, right? Job restructuring, part-time work, modified work schedules. Some people have done job sharing, things like that. Leave, but it has to be related to the employee's disability. I had a colleague who that I worked with, and she was blind, and she went for 2 weeks to the Seeing Eye Institute in New Jersey, actually, to get her guide dog, and had to take leave for that. Providing qualified readers or interpreters would be an accommodation. Next slide. Reassignment to a vacant position. This is kind of a good one. Because it's kind of the Hail Mary, again with the sports, I'm sorry, but this is kind of the Hail Mary of the accommodation process. So let's say somebody's in a situation where they can no longer do the essential functions of their job, right? Even with an accommodation, right? There's nothing that's going to help them to do this job, right? Let's say, well, I always use an example of somebody who gets in a car accident, but I'll use an example of somebody maybe who has epilepsy and their job requires them to drive, right? Their job requires them to drive. That is the nature of the job. And they have a seizure, and then they are unable to drive for 3 months. Then what happens? So can the person terminate their employment because they're not able to do the essential function? And the only accommodation would be not driving, which you don't have to take the essential function away as an accommodation. So what that person with the epilepsy or the disability could do is they could say, you know what, could I please have a transfer to a vacant position? So maybe in the company, maybe this person has background skills in accounting or bookkeeping or marketing or whatever it might be, and they could transfer that employee to a vacant position that they are qualified for, right? They don't have to create a position, kick somebody out of a position, but they can't make the person apply for that position. They actually place them in that vacant position as the accommodation. Really great accommodation. Next slide, please. Okay, so other accommodations include acquiring or modifying equipment, additional time for maybe somebody who has ADHD to get through the training or the testing or whatever that may be, modifications of policies and procedures. This is the most beautiful one of all because it doesn't cost anything to modify a policy or a procedure, right? Next slide. Okay, things that employer does not have to do. They don't, as I mentioned, they don't have to remove an essential function or hire somebody else to perform that function. Let's say, you say, I can do 70% of the job. There's 30% of the essential function I can't do. Can you hire somebody else to come in and do that? The employer does not have to do that, right? They don't have to lower the production standards, right? Unless everybody else is producing at a lower standard, right? They don't have to lower, let's say you have to make 10 calls in an hour and you say, but I can only do 6. They don't have to lower their production standards, but if there's an accommodation like a headset or something that might help you do that, they need to provide that. You cannot ask to be assigned to a different supervisor, but you can ask the manner in which you're supervised be changed. If you have an anxiety disorder and your supervisor is yelling and barking the orders and it's triggering anxiety, you can ask that they don't yell, or that all instructions are through email, or there's another person in the room, or there's so much distance between you, things like that. They don't have to promote you to a higher position or provide like duty or those things. Those are more workers' comp things. They don't have to excuse misconduct, even if it's caused by the disability. And they don't need to provide personal use items like eyeglasses, wheelchairs, prosthetic limbs, hearing aids, things like that. Next slide. Okay, we're on to resources, people. So we're going to have some time for questions should you have them. I kind of bang through this presentation. I mentioned the EEOC. That's if you want to file a complaint against your employer, that might be, the place that you could go to, EEOC, or just to ask general questions. Job Accommodation Network. I cannot speak more highly of them. It's just askjan.org, or you can call people, and they are the experts in accommodation. You can go there and look up your particular disability on their website and see accommodations, or you can talk to somebody and they'll say, oh, you know what? We worked with somebody in the past that had your similar job, and these are the accommodations that work for them. And this is where they got that piece of adaptive equipment or whatever it is, right? I mentioned the Great Lakes ADA Center that I'm affiliated with. They put on wonderful teleconferences and webinars, and they also archive everything. So I suggest that you go there and look at their stuff. Next slide. Minnesota Resources, the Minnesota Department of Human Rights. They have 13 protected classes, and Minnesota and disability is one of the 13 protected classes. They are also another place that you can file a complaint if you need to, or open an investigation against an employer or business. DEED, Rehab Services Branch of VRS Counselor. These are wonderful people, wonderful department within DEED. A part of that is also Minnesota State Services for the Blind. Next slide is me. It's ADA Minnesota. This is my contact information. I wholeheartedly offer my services to you, but I will tell you, full disclosure, I'm the only one that works there. So if you didn't like me and I'm not your thing, just know that if you call, I'm going to be the one answering the phone. And then there's also Disability Hub MN. That's also a part of the Metropolitan Center for Independent Living. And they know anything and everything about disability related services. They have DB, which is Disability Benefits 101. They know everything about benefits and MA and anything you might possibly need, they could find a resource for. So that is the condensed ADA Title I presentation. Looks like we might have a little bit of time for questions.
Absolutely. Just wanted to mention, I'm sure you all have our contact information as well. We can always help to put you in touch with folks like Cindy. So if you have any other epilepsy related issues or resources that you're looking for, we have a good catalog of that as well. So in addition to the ones that Cindy mentioned, please feel free to reach out to our information services. And yes, we are on to questions. I have the first one up, Cindy. So the question is, The standard advice for disclosure is to wait until the job offer to disclose if epilepsy is impacting your life. Is there recent research on the optimal time for, or the optimal time to disclose or to not disclose?
Oh, that is such a good question, and it's such a difficult answer because it's truly personal preference. Originally, us Minnesotans, we have to share everything about ourselves and feel morally obligated to tell the employer about your disability. But truly, if you don't need any accommodations, you do not need to disclose. But if you know that you are going to need accommodations, and you know that you are still able to do the essential functions of the job with or without an accommodation, then you don't need to disclose it at the interview. You need to disclose it when you need that accommodation. You might need it the first week of work, or you might not need it for 5 years in. If your seizures are under control, you might not need that accommodation. What you can't do is take the job and not be able to do the essential functions of the job, even with an accommodation, and then request an accommodation. Like, can you take this essential function away? I can't drive, even though the job is driving. That you can't do that. Then they would be able to terminate you. But, as long as you know that you're qualified to do the job, with or without the accommodation, you should ask for that accommodation when you need it, but you don't need to do it at the interview.
Awesome. Thank you.
Mhm.
We do have another question. Again, related actually to what you were mentioning, driving. We know that if someone has a seizure, they will lose their license for 3 months here in Minnesota. How would employers, or how would ADA relate if that was an essential function, knowing that it might only be a temporary loss of your driving privileges?
That's a tough one, because if you're taking a job that requires you to drive and you then have a seizure and are not able to drive for 3 months, you are not a qualified person to do that job. So I've had situations, honestly, I've definitely had situations where somebody was in, I can't remember what it was, maybe construction, and they were driving forklifts or whatever, and they had a seizure and they really needed to do the job. There was no accommodation. I tried vacant position, transfer to a vacant position. We tried everything, and the person really didn't have the skills to do the other vacant positions. And so they could be terminated. So you have to, it's not an entitlement program. You still have to be qualified. Now, they can't discriminate against you. Let's say your seizures are under control. You haven't had a seizure in 10 years, and you take a job that requires you to drive, and somehow your employer finds out you have epilepsy and terminates you, that's a different story. Also different guidelines for over-the-road truck drivers and pilots and things like that. So there's other federal laws, other things that would also have to be taken into consideration.
Thank you. And then the final question, would epilepsy service animals, so we know some people have service dogs,
Sure.
Would that also be covered under ADA?
Okay, well, first of all, I'm going to put a commercial in. I do a fabulous presentation on service and emotional support animals. So if you ever want to bring me back next year when you're planning your agenda, please certainly keep me in mind for that. People can call me about that. But yeah, so emotional support, let's say it's an emotional support animal for individual that has epilepsy. It's been trained to perform a specific task or duty. Maybe it's been trained to recognize when you're going to have a seizure and then bring you to safety, right? That's not an emotional support animal. That's a service animal. That would fall under all the titles of the ADA. It would fall under Title I. You could ask, let's say they have a no animals in the building rule. You would then ask, that's their policy. So you're going to ask as an accommodation for a modification of their policy that they don't allow animals, that you would be allowed to bring your epilepsy service animal into the building, right? That's just Title I. Title II and III is different. Target can't deny you the right to bring your service animal, and that's different titles of the ADA. But how it would fit under Title I is you would ask for a modification to their policy if they don't allow animals in the workplace. Now, let's just say, oh my gosh, your coworker is allergic to dogs. Then what do we do? They're asking for an accommodation not to be by your dog. Then the employer would have to figure out a way to have you in separate areas, separate offices or whatever, so that you're both accommodated, but they couldn't deny you the accommodation to have your service animal by saying, well, somebody's allergic or somebody's religion prohibits them to be around a dog or something like that. That would not be allowed for them to do. That make sense?
Thank you for that. We have a couple more questions that came in.
Okay.
This one was, does what you talked about today apply to Minnesota public schools for a student?
Okay, so that's why I'd mentioned 504. So there's IDEA, which would grant the student an IEP perhaps, or there's also the Rehab Act that covers them for a 504 plan, right, for accommodations. So we do have a problem in our schools where they say, you know, that the dog's disruptive to the other students or whatever. So I would suggest that the parent, I think we're talking about the student, right? Not the teacher, not employment.
Yes,
talking about
the student.
So students, we'll say it's public school. So we're under Title II now of the ADA as well as the Rehab Act, right? Section 504. I would put that in the students, either their 504 plan or their IEP plan, that they are to have their their epilepsy service animal to help them prior or during a seizure.
Thank you for that, Cindy. And we have one more question. If anyone has any more, please make sure to drop them into that Q&A. But this last question was, if I fill out my work's ADA request form, as part of that, can they demand that I release my medical records to them too? Yeah.
Okay.
Yes.
Okay. So, well, it depends. So they can't ask that they can never ask you to sign something that they then have a right to contact your doctor or get into all your medical records. But they can ask for medical documentation that you need this accommodation. So they may ask you to go to your neurologist and get them to fill out the forms or write some documentation that indeed you do have epilepsy and that because of your seizures, you would require this accommodation, but you never have to release all your medical records. And they only can require medical documentation for the accommodation you're asking. They can't ask to talk to your psychiatrist about your mental health condition if you're asking for an accommodation for your epilepsy and you're getting the documentation from your neurologist, right? So it's pretty limited in what they can ask for. Plus, what I say to employers is, you don't want that information because once you have it, what are you going to do with it? You know, again, separate lock file, but what if it gets leaked? What if, what if somebody makes a decision based on all that other information that they should not have? Just the medical documentation for that particular impairment, for that particular accommodation.
Thank you. And then we had a follow-up to the question about the Minnesota public schools.
Sure.
What if a school refuses to make any of these accommodations?
Okay, so if the school refuses to make any of these accommodations, I just happen to have my list here of places. So they should contact the Department of Education, Office of Civil Rights. And that's, well, first and foremost, contact the principal, contact the superintendent, work your way up, right? Don't go over anybody's head. Nobody likes that. Start with the teacher, start with the counselor, start with the social worker, on and on and on. If you've hit the superintendent, right, or the district, call the Department of Education, Office of Civil Rights. The number is 312-730-1560. Okay.
Thank you so much, Cindy. And to the person who asked that question, I will email you that information as well. Okay. Those were all of the questions we had. Thank you all so much for having joined us tonight.